In a standard negligence case, the defense attacks the plaintiff's conduct. Did they assume the risk? Were they comparatively at fault? An immunity operates differently. It shuts the case down immediately, regardless of what actually happened. Under black-letter law, an immunity acts as an absolute bar to recovery, based strictly on the status of the defendant, or their specific relationship to the plaintiff. Historically, the common law handed out these absolute protections based on rigid legal fictions. The sovereign could do no wrong. A husband and wife shared a single legal identity, making it legally impossible for one to sue the other. Modern courts and legislatures have steadily stripped away these historical shields. Denying a severely injured plaintiff a day in court requires a compelling public policy justification, and doctrines like spousal or charitable immunity no longer meet that standard. Today, only two major tort immunities survive intact: governmental immunity and parent-child immunity. While both doctrines block legitimate claims of negligence, they rely on completely distinct legal mechanics and exist to protect entirely different policy goals. To survive a motion for summary judgment against a protected defendant, a litigator must understand exactly how courts draw the precise line between actionable negligence and an absolute status-based shield. We start with the sovereign. The Federal Tort Claims Act partially waives the government's immunity, allowing citizens to sue for negligence. But the government retains a massive clawback provision known as the discretionary function exception. Courts use the two-part Gobert-Berkovitz test. First, is the government action governed by a mandatory statute, regulation, or policy? If no, the court asks, is the decision susceptible to social, economic, or political policy analysis? High-level planning and policymaking are classified as discretionary functions, granting absolute immunity from suit. By contrast, routine operational tasks that execute established policies are ministerial acts. These fail the test, leaving the government fully exposed to standard tort liability. Courts protect discretionary functions to preserve the separation of powers. They refuse to let a jury second-guess democratic resource allocation. But they do not extend that protection to the negligent execution of those choices. Consider the facts of Wisnant v. United States. The plaintiff worked at a naval base commissary. Over time, he contracted a severe respiratory illness due to prolonged exposure to toxic mold. For 3 years, government employees received warnings about standing water and massive mold accumulation in the meat department. They failed to clean it up. When the plaintiff sued under the FTCA, the government invoked the discretionary function exception. They argued that cleaning the facility required balancing budgets and allocating resources, making it a protected policy decision. The United States Court of Appeals for the Ninth Circuit reviewed the jurisdictional dismissal of the case. The court rejected the government's defense. Budgetary constraints underlie virtually all government activity. If balancing a budget transformed an action into a protected policy choice, the exception would swallow the FTCA whole. The Ninth Circuit drew a strict boundary. The design of a safety program is a protected discretionary choice. The implementation of that program is not. Removing a known biological hazard requires professional safety judgment. It involves zero political, social, or economic policy analysis. Once the government steps into the operational role of property manager, basic facility maintenance ceases to be a policy choice. It becomes a ministerial duty, fully subject to tort liability. This exact legal dichotomy between discretionary and ministerial acts extends down to municipal liability under state tort claims acts. In Peoples v. North End Baseball, a child suffered injuries after tripping in a severe pothole on a city-owned baseball field. The family sued the municipality for negligent premises liability. The city of Bridgeport claimed absolute discretionary immunity. They argued there was no formal city charter or written ordinance dictating exactly how and when they had to fill potholes. The court rejected this defense by looking past the formal statutes and examining the daily routines of the city workers based on witness testimony. They discovered an established informal policy. Designated workers were required to prepare the field before any scheduled game, inspect the grounds for holes, and report them for immediate repair. This informal practice legally removed the workers' discretion to simply ignore the hazard. A municipality cannot hide behind the shield of a protected policy decision when its own operational routines mandate an inspection. The failure to act becomes a liable ministerial omission. Now we shift away from the government entirely. Parent-child immunity operates on completely different jurisprudential logic. This doctrine does not exist to protect democratic resource allocation. It exists to protect the autonomy of the family unit, preventing courts from second-guessing cultural differences in child-rearing and domestic management. In Neal v. Sewell, a father directed his 17-year-old son to burn a pile of household garbage in the backyard. Hidden inside one of the garbage bags was an aerosol can. As the son tended the fire, the can exploded, causing severe, permanent burns. The son sued his father for negligent supervision. The plaintiff argued that instructing a teenager to burn unchecked, hazardous bags is highly dangerous and therefore cannot be considered a reasonable parenting choice. Under the Plumlee exceptions, courts use an objective authority standard. They refuse to evaluate the specific negligence of the parent's execution. If the actions were perfectly safe, no immunity defense is needed. Instead, courts look strictly at the broad category of the activity. The court ruled that assigning chores and managing household waste disposal are traditional, everyday activities that fall squarely within the scope of reasonable parental authority. Because the father's alleged negligent supervision occurred within a protected category of domestic authority, the parent-child immunity doctrine provides an absolute shield against liability. Bringing these two tracks together provides a definitive framework for evaluating any status-based tort defense. Sovereign immunity protects the government's right to govern. As we saw in Wisnant and Peoples, high-level policy design remains absolutely immune, while routine maintenance and operational implementation expose the government to standard liability. Parental immunity protects the autonomy and harmony of the family unit, and as Neal demonstrates, as long as the parent operates within a broad, recognized category of child-rearing, the absolute shield holds tight, regardless of how dangerous the specific task became. When faced with an immunity defense, litigators and students cannot let the severity of the plaintiff's injury distract them. Successful litigation requires ignoring the injury entirely. You must precisely map whether the defendant's specific conduct crossed the boundary separating a protected status from an actionable duty.